Welcome to Legalized Negligence, where we talk about Florida Statute 768.21, subsection 8. And today, Travis and I are going to break down the Senate Judiciary Committee meeting that happened on Monday, the 22nd. And we're going to take it in bits. We're going to cover like the first 28 minutes of it today. It was an hour and 48 minutes long altogether. And we're going to take each person that speaks, and if it's important, we'll stop the video and then make our comments and anything like that. And then after I get this one uploaded, I'll do the next section of it. So there'll be several parts to this to get it all in. But there was an awful lot of information shared in that meeting, and so there's an awful lot to unpack. So let me go ahead and get it up on the screen. And Travis, tell me when you can see that, and if it covers. I'm using a widescreen monitor, so let me know if you can see the whole thing there.
I can see the width of it. It's taking about the middle third.
Okay, do you see my cursor here?
I do.
Okay, that's the complete edge, and that's the right edge over there. So it looks like it's got the whole thing in there. I just never know about the aspect ratio using this monitor. All right, where this thing opens, Senator Yarborough turns the meeting over to Senator Burton, because since it's his bill, he has to turn the chair over to her. She takes over and lets him introduce his bill. And there's actually three things going on here: his bill, his amendment to his bill, and then Senator Book introduces an amendment to his amendment. So we're going to take it piece by piece, and we'll see what they have to say. I'm going to make sure my volume's up here. Sometimes you've told me that you can't hear it very well, so let me know if I need to increase that volume.
Okay, members, we will go ahead and reconvene. At this time, I will pass the chair to Vice Chair Burton so that I may present a bill.
Thank you, Chair. All right, members, we are on tab 1, which is Senate Bill 248 on medical negligence by Senator Yarborough. Senator Yarborough, I see you have a delete all amendment to the bill, so let's go straight to that delete all. Members, we're going to look at amendment barcode 932842. Senator Yarborough, you're recognized to explain the amendment.
Thank you, Madam Chair. Senators, like many of you at your local delegation meetings here at the Capitol and/or through phone calls and emails, I've learned about and listened to the stories of a number of individuals who were impacted by the wrongful death exception currently in Statute 768-21A that was enacted in 1990. In full respectful candor, let me be clear that the sole reason I have placed this issue in front of us is because while an effort to reduce medical malpractice insurance premiums at the time was a worthy pursuit, implementing a ban on certain individuals to where they could not and still cannot access their judicial system to plead their case is a clear injustice.
I'm going to pause it there for a minute. Keep that in mind, what he just said. For 34 years, the people of Florida who have been affected by subsection 8 have had their rights violated, and it was an injustice. He recognizes that. It's taken 34 years for the legislature to do anything about that. And I'm going to reference that later when someone else speaks. I'm going to go back to what he said about it being an injustice.
If a decedent was past their 25th birthday, had no children under the age of 25, and was not married, no one may bring an action alleging medical negligence. I'm unaware of a way for us to know how many legitimate claims of medical negligence might have existed over the past 34 years since this exception was made law, but I am confident that with a population like Florida's, undoubtedly in that time frame, legitimate issues of negligence are bound to have existed.
I'm going to pause it there again. He says, here, coming up, he talks about hundreds or even thousands of people who have been affected by this, but he said there was no way for them to know how many. So why wasn't there a way for them to know? Because they couldn't get into the civil court. So he just admitted that hundreds or even thousands of people have had an injustice forced upon them for 34 years simply because the legislature back in 1990 denied them the right to access the civil court. The legislature is fully responsible for that infringement upon their rights.
For this reason, I put before the committee today a repeal of 768-21-8 in order to provide access for those who do not have it today. But because efforts over the last several years to do a clean repeal of the subsection have not garnered enough support to pass the legislature, I knew we would need to find a way to thread the needle and strike a balance if we hope to help impacted individuals. Arguably, repealing the subsection could likely result in higher insurance premiums. To offset this impact and also to afford all of our constituents the opportunity to benefit from lower healthcare costs, I am also proposing that we add caps on non-economic damages if a claim relates to wrongful death stemming from medical negligence or personal injury stemming from medical negligence. As I put forward in the whereas clauses and findings, Florida has the highest medical malpractice insurance premiums in the nation. We also have a rapidly growing population and changing demographics, that dictate the need to have a legal environment favorable to attracting and retaining physicians, especially our high-risk physicians. While not an official part of President Pasadomo's and Senator Burton's excellent Live Healthy initiative, this effort comes favorably alongside and runs parallel. While the imposition of non-economic damage caps enacted in 2003 were subsequently struck down by the Florida Supreme Court in 2014 and 2017, the amendment contains a cure for the primary issue upon which the court took issue, which was equal protection.
I'm going to pause it there. I want to go back. I didn't have time this morning to do it, but I want to go back and look at this equal protection issue that he's talking about. He gives one understanding of equal protection, but I don't know that that's the accurate understanding. I think the court found it unconstitutional because it didn't provide equal protection, was that everybody didn't get an opportunity to go to the court. But listen to how he defines equal protection.
The court opined that multiple claimants would not be entitled to recovery of damages up to the cap amounts. Also, some claimants could receive higher awards based on severity of injury, while others could not. To fix the court's concern, this amendment moves from aggregate caps to per claimant caps and also removes the categorical distinctions to ensure all claimants can receive a full award of damages up to the caps.
Now, do you see what I'm talking about?
Yeah.
It sounds to me like his understanding of equal justice or equal protection, I should say, has to do with how many claimants, and those are the plaintiffs, the people who were suing for, can recover damages. And I need to go back and reread Gallatin and reread McCall and see if that's what the court held in those cases. And I'll get to that. It was just impossible to get to that this morning. You have anything you want to add to that right now?
Not yet.
Okay. Now, what he's about to do is tell you what the bill includes. So pay attention because he clarifies a lot of things here that most people are misunderstanding about his bill.
With all of that as background, here are the specifics included in the amendment before you today, barcode 932842. The amendment again repeals the wrongful death exception. It removes the probable cause process contemplated in the filed version of Senate Bill 248, adds caps on non-economic damages for medical negligence related wrongful death and medical negligence related personal injury claims of $500,000 for practitioners and $750,000 for non-practitioners. As a side note for clarity, the amendment does not include any caps or limitations on economic damages, i.e. for medical expenses, funeral expenses, lost wages, or the like, so a jury in court would not be limited to making such awards at levels they deem reasonable.
I'm going to pause it there because of the conversation you and I had last night, Travis, about economic damages. There are a number of things you brought to my attention that could be considered economic damages that I don't think have ever been considered by the Florida legislature. What they're looking at is, say, like, a husband is the breadwinner. he dies because of malpractice, they're able to sue. Well, they can sue for future wages. They can sue for, lost income. They can sue for all these different things. But the things that you have talked about, I've never heard anybody talk about it before. And when we've discussed it, they've made sense to me. And maybe we should do a podcast just on that sometime.
All right, well, let's give the people an idea of what I mentioned.
Okay.
Prime example is if the decedent is no longer able to make the house payment, someone's got to make it, or you fall into foreclosure. So you have to make the mortgage. That's a result of the death. That is not covered under their current definition of economic damages.
Okay, now I don't want to get into a long discussion about it now because this is going to be long enough on its own. But the way that I would view that is if you can sue for future wages, then wouldn't that cover the mortgage payments? Let's say that the decedent was earning $100,000 a year and they died because of malpractice. And every month they were paying $1,000, just to make the numbers simple. They were paying $1,000 a month in a mortgage payment. Well, if you can sue for their future wages that they've lost, wouldn't that cover the mortgage payments?
No, the reason being is it's net, which means your expenses are taken out of what you get in those future earnings.
Okay, this is why I think we need to do it.
So you take the living expenses, you subtract that from the future earnings. You aren't allowed to recover the living expenses. The mortgage is part of the living expenses.
Right.
Only the profits that would have been left over are what you're able to recoup.
Okay, well, we'll do a podcast on that because that's a fascinating subject to me, because it may be that they need to go back and look at what they consider economic damages because they may not be taking everything into account.
Right.
Replaces aggregate damage caps with per claimant caps, removes the categorical differences based on type of injury, thus treating all damage claims equally. It requires medical malpractice insurers to include in their rate filings with the Office of Insurance Regulation information related to projected changes in claim frequency, claim severity, and loss adjustment expenses. Also, OIR must ensure the rates for coverage account for this legislation. It requires the Office of Program Policy Analysis and Government Accountability, or OPAGA, to study the statutory caps and evaluate the availability, affordability, and volatility of professional liability insurance coverage for medical negligence, plus the per capita supply of licensed physicians in the state. OPAGA must issue a report to legislative leaders and the governor by December 31st, 2029, which includes in its findings and recommendations whether the caps on non-economic damages should be retained, modified, or eliminated. Lastly, the amendment includes findings to support the legislation and has an effective date of July 1st, 2024, plus clear language, that it only applies to claims that accrue on or after July 1st, 2024. Madam Chair, that is the amendment.
Okay. Two things I want to talk about there is I know a lot of people don't understand what he means when he talks about aggregate caps versus per claimant caps. What he sounds like he's describing here is his amendment allows more than one claimant. And when it says that the cap is $500,000, that means that more than one claimant, let's say you have three brothers in a family, they're all adult children, and their mom died from malpractice. Those three brothers could each, if the doctor is found negligent, those three brothers each could recover up to $500,000 apiece. Is that how you understand that?
Correct.
Okay, and the aggregate, which it had been before, was no matter how many family members you had, they could all recover, but in total, it could not go over 500,000. So to me, that sounds like a win. If I'm not saying that I agree with caps, but it sounds like it adds more people in, more family members in to let them recover. So it's not like $500,000 that has to be divided among three people. It's 500,000 each. And the other thing, now I forgot what I was going to say about it. there was something else he said in there. Oh, well, we'll get it later.
Thank you, Senator Yarborough. Senators, we have a,
Okay, this is where Senator Book is going to introduce her amendment to his amendment. And I'll warn you, the first minute or so of this is a mutual admiration society. So just you'll have to sit through it and listen to it.
late filed amendment to Senator Yarborough's amendment. And to put us in the proper posture, seeing no objection, we'll take up late filed amendment BARD code 651-228 by Senator Book. And Senator Book, you're recognized to explain the amendment to the amendment.
Thank you very much, Madam Chair. And before I get into the substance of the amendment, I just want to thank the chair for his hard work, for everyone in the room to try to keep everybody calm. I think that this is a chair who knows every single one of your family members. He cares about every single one of you and the work that you have put in, and really does. And so I just want to first, before I even get into the substance of the amendment, thank him for that, because when he's here at 9 or 10 o'clock at night working through these issues, he really is. And I see the family members nodding their head, and I know that they know that. And so, Mr. Chair, I think that speaks to who and what you are in this process. So I first wanted to put that on the record and say that. So thank you. And
I'm going to pause that just because I have to make a comment here. I admire Senator Book. I mean, she obviously, you can listen to her, and repealing subsection 8 means a great deal to her. But what she just said reminded me of when I was a kid, and my mom used to say, I love you and I want the best for you. So I'm going to still have to beat you, or I'm going to still have to restrict you, or I'm going to still have to do something damaging to you. But I just want you to know that I really love and care about you. So, but that's just what they do in politics.
so you and I have talked a lot about this process, and I want to thank you and your staff for all of your hard work on this bill over the past year. And I know that we've continued to work through it. And while I understand that your amendment aims to allow these families access to the courts without opening up the hospitals and doctors to an extreme level of liability, I have a hard time putting a dollar amount on the pain and suffering felt by some of these families. And you and I have talked a little bit about that. So my amendment would simply repeal subsection 8 of the statute, and without imposing any of the caps on economic damages. I'm not sure that trading one injustice and limiting another is the right way to go. So that is my amendment, Madam Chair.
Thank you, Senator Book. Do we have any questions on the amendment to the amendment? Senator Harrell?
Thank you. Just to be sure, I want to make sure I'm understanding exactly what you're doing. You are removing the whole aspect of the bill that reinstitutes and readdresses the issue of caps. All non-economic caps would be eliminated under your amendment. Is that correct?
Senator Book?
Yes, Madam. Yes.
Thank you. Additional questions? We have a few appearance cards on where
Okay, now what's going to happen is there's going to be several people that come up and speak and give some comment on this. And at this stage of the game, since they're only 8 minutes into it, these people speak for 3 and 4 minutes at a time. This first fella who's going to speak, I wish I could understand his last name because I'd like to contact him. He's with the FJA, which is a Trial Lawyers Association, and he actually supports what you and I want. He wants to see subsection 8 repealed without any caveats put on it about caps. He speaks now, but then later on when they get back to the amendment and then the bill, he speaks again.
So this is on the amendment to the amendment. We have many appearance cards on this issue today. So these are for the amendment to the amendment. So that's the point Senator Book just made. Eric Tinsman. Mr. Tinsman here, who will be followed by Andrew Bolin. And I'm going to ask you, just because there's so many and you may be up later, please keep your comments as brief as you possibly can.
I will. Thank you very much.
You're recognized.
Senator Book, Chairman Yarborough, thank you for having us here. Senator Book, thank you very much for this amendment. My name is Eric Tinsman. I'm here on behalf of the FJA. I think if everyone in here had to list the #1 thing they wanted to accomplish today in this committee, maybe not everybody, but most people would say if they had to pick one thing, it's to get rid of this med mal wrongful death exception. We disagree after that, but everyone here, most people here want to get rid of that. This amendment by Senator Book does that. So thank you, Senator Book. I have been in the position as a medical malpractice trial lawyer to get these calls. It is heartbreaking to have a client call, have a client say, I'm 55 years old. My son is 28. He went for a routine procedure. He didn't come out. And I sit there and I wait to hear their entire story because I want them to have an opportunity to explain themselves. At the end, you have to tell them there's no case. You cannot do this in this state. There's an exception for an adult child who's over 25. There's nothing you can do. And with Senator Book's amendment, we are able to do that. I thank you very much for that. I thank you for your time, and God bless.
Okay, now the guy that's going to come up and speak is, he's an attorney. He defends doctors who are being sued for malpractice. His name is Andy Bolin. He's been in a couple of news stories that have played over the last few months. And he doesn't want subsection 8 repealed. And now that it looks like that may happen, he's the one that's really pushing to put these caps in place. So I've got a lot to say about what he says. So I'm going to let him speak, and then I'm going to stop it throughout so I can raise questions about what he has to say.
Thank you. Andrew Bolin, who will be followed by Belinda Warren. Mr. Bolin, you recognize?
Thank you very much. Andy Bolin on behalf of the Florida Justice Reform Institute. I'm a medical malpractice defense attorney, and I represent Florida's healthcare providers all over the state in medical malpractice litigation. I'm here today in opposition, respectfully, of the amendment 651-228 because—
Excuse me, Mr. Bolin, we're on the amendment to the amendment. That's when you're speaking to. I'm just making sure I'm in the right place with you. Okay,
yes, ma'am.
Thank you.
Yes, ma'am. So I'm in opposition to the amendment on the amendment because it eliminates the protections that are written in to the amendment by Senator Yarborough.
I want to know what protections. These protections that he's talking about are things that keep doctors from having to be accountable. You know, the fact that if subsection 8 is repealed, people will be able to get into a civil court and put a doctor on a witness stand and ask questions and rebut, call witnesses, produce evidence, things that we can't do now with the Department of Health. So when you hear him say protections, you got to think about who is being protected. You know, the doctors are being protected from being accountable for their negligence. And Travis, please feel free to say something in here if you want.
Well, I got my list from the email I sent to you, but he's still speaking, so I don't want to go through my list.
Okay, well, stop me if he says something that you want to comment on.
If we are going to expand the universe of claimants in the state of Florida, there must be some countermeasure, some counterbalance that is going to provide fairness and balance in the civil justice system. There's no way for us to know exactly how many of these claims are out there. We certainly hear for several years, we've talked about this subject. We've heard from from proponents of the bill and the fact that they turn away these cases regularly. I've done media appearance here recently where I believe it's the largest plaintiffs firm in Florida said that they turn away several of these cases per week. So we know there are hundreds of these cases, if not thousands of them, that are going to be filed each and every year.
Okay, let's pause and talk about that. He just admitted that there are hundreds, if not thousands of cases every year that people have not been able to get into the civil court. In other words, medical malpractice may or may not have happened. It may or may not have taken place, but the people were denied their right to access the court for it to be proven whether or not the doctor was negligent.
Well, even before that, they haven't had the opportunity to get an attorney to find an expert witness to review the case because it's just not worth it to them. You know, that expert witness is really who determines, do they have a case or not? And we can't even get that far.
Right. And he's trying to present this argument as if this goes through, then hundreds or up to thousands of new cases will start to be flooded into the civil courts. What he's not saying is that those are the people who have been denied their rights. He admitted thousands of people every year are being denied access to the court, and he seems to be okay with that. Let him keep speaking here before my blood pressure goes up.
So if we are going to remove that prohibition, then we also must have some counterbalance in the system. And so that's why I'm opposed to the amendment. Thank you.
Another thing that I wanted to say about that, I said earlier that I was going to go back and reference what Senator Yarborough said at the beginning when he said this is an injustice. Bolin just said hundreds or thousands of people a year are being subject to injustice. Does that make sense? If Yarborough categorizes it as injustice and he says there's hundreds or thousands of them, that means hundreds or thousands of times every year injustice is being committed in the state of Florida, thanks to their law.
And he's also saying that they must, not should, but must have protections for his doctors.
Yeah, and that's why I keep going, protection from what, man? You know, you're not addressing the actual malpractice that takes place. It's like we're just supposed to forgive that. Anyway, I'm going to, let me see, how can I do this? I'm going to mute this for a minute while I get this up to where I want it to be. I'm looking, so hold on for just a minute. The next section is at 18. Let me see if I can get it up there. That's 27, 25, 22, 18. Okay, that was, all right, let me try that and see if I got it now.
Thank you very much. And I have to respectfully vote no on this because it really changed.
Okay, this is where the debate began. I can't seem to get it exactly where I want it. Let me try that.
That all doctors pay. Why should only those pay? I can't.
Amendment, Senator Harrell.
Thank you very much. And I have to respectfully vote no on this because it really changes the intent of the amendment, the original amendment, and it eliminates the counterbalance that I think is very essential. If we are doing so much in the state to bring physicians to the state of Florida, the whole Live Healthy initiative that we are doing is really to create our workforce and to build our physician services. If we pass this amendment, we are going to eliminate the opportunity to put caps into these non-economic damages. It does not change the whole issue on wrongful death. It does nothing to touch that. So what our wonderful constituents are saying to us is not going to be changed by this. This eliminates that counterbalance that allows us to bring more physicians into the state of Florida, and people won't be scared away by the horrendous cost of medical malpractice insurance. This will eliminate those massive awards that may not be necessary. This will go, I'm sure, before the Supreme Court. It'll be litigated, I am sure. And I believe that this is the right direction to go and to make sure that we have a workforce. You do want to have care in the state of Florida. And at the rate malpractice rates are going, we're not going to have physicians come here if we don't do something to address this. So I have to respectfully vote no on this, and I hope other senators will join me.
Did you hear her admittance?
Yeah, but go ahead, because I have something I wanted to add too, but I've been talking too much, so you go ahead.
She admitted that the amendment does nothing to correct the underlying issue, which is medical malpractice occurring.
And when I heard her say that, I'll tell you what thought went through my head. If I was a doctor practicing in another state and I knew that I could move my practice to Florida and not have to carry medical malpractice insurance, do you think that I would be concerned about moving to Florida? I'm not going to be looking at the malpractice rates, the malpractice insurance rates, if I know that I don't have to carry malpractice insurance. You know,
Senator
now
Thompson?
think about that.
Thank you, Madam Chair.
If that was,
She cares about the number of medical professionals and not the quality of those professionals.
yeah, that's all it is to her. And we've heard, you and I have both heard the term second chance state. Florida is a second chance state. Doctors move to Florida who've had their license pulled in other states or have been sued for malpractice in other states. And so they move to Florida because they know they're protected by subsection 8. And then we also know the number of doctors that term they use is go bear, which means they don't have to carry insurance. So why are they going to worry about the price of malpractice insurance if they don't even have to carry it? You know? And Andy Bolin even discussed that in a news story he did earlier this year, probably a month or two ago. But let me see. Now we get on to Senator Thompson is gonna, I think that's his name, is gonna speak. He actually supports, or she supports us.
I like her.
Yeah, I do too. She's well thought out. Something tells me she's read some of the information that I've sent because it sounds like that's where she's getting her arguments from. But let's listen to her. I really like this lady.
I'm speaking in support of this amendment to the amendment. In 2014, these caps were struck down because they did not provide equal protection. And I think that everyone has the right to stand before the law and have their case decided by a jury rather than this legislature. And in the 11 years since the caps were struck down, there is no evidence whatsoever that medical malpractice premiums went down. So this has no bearing on medical malpractice premiums. And certainly we want physicians, we want healthcare professionals in Florida, but this does not address that particular problem. And I hope we will support Senator Book's very good amendment to the amendment. Thank you, Madam Chair.
Yeah, I really like her a lot. She makes some very good points. They seem well reasoned. She recognizes that, she said, who is the legislature to make this decision? Let a jury make this decision. If we're a self-governed country or a self-governed state, shouldn't the people be speaking? So the next guy.
Didn't we back with the vote? They tried to pass a bill.
That amendment back in 1988?
Yeah, the amendment.
Yeah, in 1988, and I've addressed this in other podcasts. In 1988, when all this stuff was ginning up, 2 years before before subsection 8 became law, the task force had just turned over its findings to the legislature. And so the legislature thought they would test that. And they put Amendment 10 on the ballot that year in 1988, asking the people if they wanted, if they would agree to have caps on damages and tort claims. And the people said, absolutely not. And it was defeated. And still the legislature thinks that they have the authority to do something that the people don't agree with. This next guy that speaks, I think his name is pronounced Senator Albritton, I believe. He opposes it and he gives his reasons why. So let's listen to what he's got to say.
Thank you, Senator Albritton. You recognized?
Thank you, Madam Chair. So Senator Book, I think probably everybody in the room and certainly everyone on this dais knows how deeply you care about this issue and how you many times lead with your heart. And that is an incredible strength. But thank you for that. I'm going to be down on this today because, the chair has worked very hard to strike balance in this entire process. And by the way, to each of you, that's not easy. It certainly is not easy to sit here and listen to many of these stories and then have this emotional pull to get you away from the economic discussion too, because you have to have both. You can't create an environment in Florida where there are these endless possibilities for litigation, regardless of, and please forgive me, I want you to know, please forgive me, regardless of the amount of hurt, because the problem is the greater good gets damaged.
All right, I'm going to stop it there. The greater good. It is a tough position to be in when you're a senator. Travis, do you mind if I give a real quick history lesson here about senators? And
Go ahead.
I'm going to start off on the federal level because it's a lot easier to understand on the federal level. When America was created, after we separated from England, all the 13 colonies had become states, and they all had their independent governments in those states. And then in 1787, when the Constitution was written, the states had gotten together and talked about, there's some things that we do in common. And it would be better to have one government that controlled those things versus each individual state controlling those things. One of them, an easy one to understand, is currency. Every state had its own currency before 1787 when the Constitution was written. So they wanted one currency that could be used in all the states. And then it dealt with travel and a number of other things. In fact, there's 18 of them listed in Article 1, Section 8 of the Federal Constitution. So when they created the federal government, they had a House of Representatives, and those representatives represent the people's interest. And at that time, each state's legislature elected 2 senators to go to Washington, D.C. and represent the state's interest. So just because the people of the state wanted one thing, it might not, imagine, and I've used this example before, what the people in Miami want may not be the same thing that the people in Ocala want, So a senator's job is to look out for the best interest and the greater good of the state, where the representative's job is to look out for the people's interests. So the representatives bring up something, say, my people want this, they discuss it, then it goes to the Senate, and the Senate says, well, okay, I understand the people want that, but we got to think about the whole state. So if you now in 1913, that changed. I believe it was the 17th Amendment, if I remember right, where the people began to elect the senators who went to Washington versus the states representing this or electing the senators that went to Washington. Now take that theory and put it on your state. If the representatives in your state represent the people's interest, these senators' job are to see how those interests balance against the interest of the state as a whole. So they have a different approach than the people in the House of Representatives. And I can understand their argument. If the people wanted something that is going to harm the state in some way, then they need to consider that. So that's why he's talking about the greater good. He's not necessarily talking about the individual doctor, but the greater good. So what would that greater good be in this case? That greater good would be that doctors don't leave the state and people have availability to health care. But what he's basing that on has been only one set of numbers or data or stories from the lobbyist. They don't tell him the whole story, that he still believes, and just like Senator Harrell did before him, they still believe that doctors are fleeing the state because malpractice insurance is too high. So what we've been trying to do is trying to show them that those numbers are not accurate. Look at just recently, a news station did a story where they showed that only 6% of doctors are saying they leave the state because of medical liability problems. That means 94% are leaving the state for other reasons. So let me go ahead and start him back again here.
And rates go incredibly high, healthcare becomes even more unaffordable, and we have a problem with doctors. We already have one now. But this is hard. It's hard to strike balance. Just that piece is the reason that I am not going to support this amendment to the amendment today, because I believe the chairman is on the right track. He's looking for balance, trying to figure out what it looks like. That's hard, and I appreciate the work you're doing on it. But, Madam Leader, I'm going to have to be down on your amendment.
I think we need to send him some information. I think we need.
I agree.
So that he needs to see it. But clearly, Senator Thompson gets it. Clearly, Senator Book gets it, and I think Senator Harrell and Senator Albritton. I think we need to send them some of the research that we've done to show that those numbers are not accurate. Now, Senator Yarborough is going to talk about his bill a little bit before they close on this.
Thank you. Senator Yarborough, you recognize?
Thank you, Chair. Thank you, members. Senator Book, I'll echo too what the leader just said, and some others have mentioned it too, both in speaking at the podium and on the dais. You have been looking at this issue since before I came to the Senate a year ago, and then before that, I know you have sponsored bills over here when we had taken up bills related to this in the House. When I was a member of the House, I voted for essentially the substance of what your amendment is. In looking at the situation and the history, we, again, as I said in my opening, I don't believe we have enough support just for that, and it would take us away from the balanced approach that the leader and others have articulated. I do want to say for the record, though, that just a couple of speakers mentioned it, and then Senator Thompson, you made a very good point about really going to some of the findings that I've included, and I'm not getting off of what Senator Book's amendment is, but just wanted to mention this because it came up in testimony. We do have reports that I've looked at. Belinda, I wanted to say thank you for sending what you said about Statista. I saw your email on that. I have researched, though, and found the Medical Liability Monitor Annual Rate Survey issue, October 23, volume 48, number 10, and also a Guy Carpenter study, which performed an analysis of medical professional liability state by state. That was in November of 2023. It's about 200 pages, pretty long. Those do give rise to Florida having the highest medical malpractice insurance premiums in the nation. So in continuing to look at balance, again, taking into consideration what you said, I'm interested in any other data anyone wants to send us, but we do have reports that show that Florida is the highest in the nation, which is what, again, one of the findings is based on.
Okay, I'm going to pause it there because even if he's correct here, that doesn't necessarily mean that lawsuits against doctors for malpractice is what has caused their malpractice rates to be higher than any other state. I think it probably has more to do with the fact that not all doctors have to carry, or not all doctors carry insurance in Florida. And I've mentioned that in previous podcasts where I've talked about if you only have 100 doctors paying into a pool that an insurance company is going to have to draw from to make malpractice payouts, of course the rates are going to be high. But if you had 1,000 doctors paying into that same pool, you could lower their premiums and still have a large enough reserve to be able to make those payouts. This is a book that I plan to get into in another podcast coming up that has to do with all this, that explains about the boom bust cycle of the insurance industry. And this attorney, Tom Baker, who wrote this book, whose his father and his father-in-law are doctors, he explains exactly how that cycle works, and that insurance companies take advantage of that cycle. They keep insurance premiums so low that it causes them to not have enough money in their reserve, and then they jack it up, and doctors start screaming, my God, the sky is falling, the world's coming to an end, my rates have tripled. Well, maybe if the riders, the insurance companies, would have kept enough money in the reserves to begin with, then this would not be a problem. It would not be a cyclical problem that comes along every 5 to 6 years.
Yeah, well, if you read the MLM,
Go ahead, I'm sorry.
if you read the medical liability monitor that he stated, I found in there that the indicated rate that the insurance premium should have gone up to is not met by the actual rate requested to be applied to the premium. In other words, they're purposely undercharging the premium rate, causing an insolvency issue.
Yeah.
And that gives them an argument to say, hey, we're making a loss every year. And yet they keep their rates lower than what they should be. They need to just charge what they need to, get their actuarial reserves where they need to be, and then move on from there. But I sent that to one of the lobbyists, and he refused to answer my questions about it.
Yeah. And Tom Baker in this book talks about that very thing, and how they strategically lower their rates and raise their rates to create that problem. And another thing to think about, when doctors pay in their premiums into an insurance company, that money just doesn't sit there. That money is invested, and it's invested in order to make money. So it might be that they need to invest their money a little differently. Do you follow what I'm saying there? Maybe they should spend less money on the CEO's take-home pay and invest it in places that would put more money back into the pool that is going to have to be drawn from when a doctor commits malpractice. In other words, this whole thing is an insurance issue. It's got nothing to do with people suing over malpractice. And as Tom Baker says in this book, Florida has a malpractice problem. They don't have a frivolous lawsuit problem. They've got a malpractice problem. And as Andy Bolin admitted, thousands of people are being unjustly denied their right to court, and the doctors go without any accountability for it. Let me go ahead and finish up with what he's saying.
You had mentioned about evidence on nothing shows that anything has changed since the caps had been put in 2003. Our own Office of Insurance Regulation did a 2010 annual report, medical malpractice financial information, closed claim database and rate filings, and mentioned during 2009, 10 new medical malpractice riders entered the Florida medical malpractice insurance market. And then also, based on the analysis contained in the report, it appears that the solvency of the medical malpractice insurers was enhanced by the introduction of the 2003 legislative reforms. And then page 12 of this report identifies that from 2004 to 2009, once the caps had just been put in place, we saw a 36% decrease in the insurance rates. So,
okay, Senator Yarborough seems like a smart guy, but I don't know how he can allow himself to be manipulated by these statistics here. Think about it. And let's just pick a year. I think he said 2003 or 2004. Let's just pick a year. I don't care what year it is. And suddenly you put caps on people being able to recover. So what that means is the insurance companies are not having to pay out as much. All right. So their reserves stay at a higher level. After a few years go by, those reserves keep building up and building up. And what he is saying is that because those reserves build up, the premiums came down. The doctors weren't having to pay so much for medical malpractice. But why? Well, they came down because people weren't able to sue negligent doctors, and they create this cycle. We just had snow here where I live. We weren't able to get to the grocery store for nearly 2 weeks. Then when my wife finally went to the grocery store, our grocery budget tripled. Oh my God, what's happened? We're not going to be able to eat anymore. Groceries, no, they didn't. We had not been able to go to the grocery store once a week like we normally do. So when my wife did get to go to the grocery store, it was triple what it was when she gets to go every week. You see how he's being manipulated by these numbers? Or am I just ranting? I'm sorry, Travis. I'll try to be quiet. I just can't believe that they can't see through this.
My respectful contention would be it did work. The reforms did work that the legislature put in 03. And then we saw an uptick come whenever the caps were struck down by our court. And again, we can get more into that in the questions back on the main amendment. But for those reasons, I must respectfully say the amendment is unfriendly. Leader Book, it's with sincerity and respect. I appreciate your work, but I can't support the amendment.
Senator Book, you're recognized to close on the amendment.
Thank you so much, Madam Chair. And I appreciate all of the commentary and back and forth, because I believe this is the upper chamber, and we can have incredible dialogue, and we don't fear the debate. And I think that that's a wonderful piece in how we make good policy. And I know another great way we make good policy, and that's the chair, who is incredibly dedicated to this issue. And when I say to these families again that he knows every single one of you, he reads all of the emails, I bother him all the time. I get it. And I know that this is a hard thing, and you're trying to thread a needle in a very difficult way. And I want to thank you for that. And I want to thank you for the love and kindness that you show these families more than anything else. I do. I just also believe that putting malpractice caps or any other hurdles in the way of any victim of malpractice isn't what we could be doing, and isn't what we should be doing necessarily. I believe that these cases are already extraordinarily very difficult to bring, and there has never been any evidence that these cases are brought frivolously. These are a lot of times the worst of the worst. And I know that this Florida Senate works to our greatest good, and I believe that we can do hard things. And you're doing hard things, Mr. Chair. You're doing hard things by working through this. And so I would challenge each and every one of us to try and vote yes and find it in themselves to remove these caps and do a straight repeal free kill. Because I don't believe that this is a law that any one of us would want right on the books. But I would also challenge all of our stakeholders to continue to have this dialogue, because I am also really good at math. And I know that the likelihood that this amendment is going to pass isn't that great. But I would ask that we continue to look within ourselves. We know that the free kill law isn't what should be on the books. We've talked about that. And I know that we can do this in a different way. And so I would ask for your favorable support of this amendment, and we'll see where it goes from there.
All in favor of the amendment say yay. All opposed say nay. No. Will show that the amendment fails. We are back.
Okay, now that was, I'm going to go ahead and stop sharing this because I'm not going to go any further with that video right now. That was Senator Book's amendment to Senator Yarborough's amendment to Senator Yarborough's bill that just failed. Senator Book says that she's good at math. I think I'll send her some numbers and see if she can get those people to understand them, because it makes no sense to me how they can believe, you know, I don't know. If I can find these books and read them, they can find them and read them. And they're the ones getting paid to know this stuff. And
They may just want to be spoon fed.
I guess. So what's your take on the first 28 minutes of the meeting, Travis? I know that I've run my mouth enough the last hour.
I'm kind of biased towards my own solution, but it's difficult to rationalize some of their arguments when you know there's a better way that they just haven't been told, spoon-fed it yet.
Yeah,
But they're totally all missing the cause of medical malpractice claims, and that is medical malpractice occurring. And that's solely in the control of the practitioner. And yet they do nothing to improve the actions of the practitioner. They
Yeah,
are only interested in the end result, mitigation of the damage, which is for them profits, costs right now. They don't care about the people because they do nothing about them.
yeah. I don't see anywhere in any of this where anybody is addressing anything to do with the malpractice itself. And like I was saying to you on the phone last night, I would like to see an overhaul of the Department of Health and ACA and have the legislature make those agencies do what they were set up to do and make it where they're not advocating for the doctors. In fact, on our next video, and I might do a separate podcast just on this. This guy that wrote this book, Tom Baker, I found some stuff on YouTube from him last night, and he makes some excellent points. And maybe we should just do a quick little video on that because they're only like 3 or 4 minute videos, and listen to the things that he says. I've tried to suggest this book to people and have them read it if they want to understand this problem. It actually began back in the mid 1970s. For anybody to think that it just suddenly happened in the 1980s is nonsense. This has been going on. I think it is, my personal opinion is that this is somehow tied to the tort reform that Governor DeSantis signed into law in March of last year. I think that they are working on a much larger picture, and we're only seeing little segments of that with each of these things. I think they're heading to something much larger than this, that in my personal belief, it's got to do with socialized medicine. Them bringing socialized medicine in. I know Hillary Clinton tried to do it back in the 90s, and when all of that failed, they have slowly been piecing it together, little pieces at a time, and I think they're trying to force socialized medicine on us. That's
Yes.
just my own thoughts.
Before we were talking about the failed amendment initiative, Amendment 10.
Mhm.
I was wondering, could a failed attempt at establishing the amendment create the negative amendment? In other words, they tried to pass caps via an amendment, but the people spoke and said no. So could that technically have created an amendment saying no caps?
Well,
Obviously it didn't, but
Yeah.
I'm just wondering, could you do a wording such that, the amendment will have caps, and if not passed, we will have an amendment of no caps?
yeah, I'm not smart enough to know the answer to that, or to know how you would make that happen. I think that going by what sorry, I keep coughing. I'm still recovering from the flu. I think that when Yarborough was given his understanding of due process and equal protection that the courts found in Gallatin and in McCall, I think he's misunderstanding that. I'm going to go back and read them and see if maybe I'm the one that got it wrong. But he's trying to say that his amendment cures that problem by getting away from aggregate caps to a per claimant cap. And I'm sorry, I'm going to have to end this, man. I'm getting into a little coughing jag here with this, but that's the first 28 minutes of it. We'll take another chunk of it. I'm going to get this one uploaded, and then we'll try to attack the next section of it in the next podcast. Anything you
Sounds like a plan.
All right. Thank you, Travis. Hang on just a minute after I stop this recording, and we'll talk a minute.